welcome everybody. I sure appreciate you coming here, especially on such a rainy day. I was a little concerned because we didn't get a whole lot of publicity, and I was hoping that people would come out because our speaker has come all the way from William and Mary to speak to us. And he said that he is neither fish nor fowl. And I'll explain that when you hear his credentials. He is the Woodbridge Professor of Law at William and Mary. His areas, not just one area, areas of specialization are civil procedure, conflict of laws, constitutional law, continental philosophy, federal courts, jurisprudence, philosophy of law, and last but not least, professional responsibility. He joined the faculty in 2006 after teaching law at George Mason Law School. He clerked for Judge Richard A. Posner in the U.S. Court of Appeals for the Second Circuit. He practiced law at Paul, Weiss, Rifkind, Wharton, and Garrison in New York City. He was an assistant professor of philosophy at Tufts University and a visiting lecturer in philosophy at the University of Alabama, Huntsville, Wesleyan University, and Yale University. He's the author of Nietzsche and the Transcendental Tradition in 2002, and numerous articles and essays, several which apply to our topic today. He was part of a symposium, Law's Dark Matter, at William and Mary Law Review, Why Protect Private Arms Possession, 9 Theories of the Second Amendment. So you're not just going to get 1 or 2, you might get 9. And The Paradox of Auxiliary Rights, the Privilege Against Self-Incrimination, and the Right to Keep and Bear Arms. So if we could all welcome Dr. Michael Stephen Green.
Thanks very much. Yes, in saying that I'm neither a fish nor fowl, what I meant was I'm not really coming before you as an advocate of the Second Amendment or as a critic of the Second Amendment. My goal really is to just try to understand and describe the various arguments that exist for the Second Amendment and the problems that they have. I'm not going to be uncritical. There's only certain arguments that I think have really a chance of working, and I will describe what I think are some problems with them. But I'm really serious in saying that my goal here is not to change anybody's mind about the Second Amendment, but rather to help you understand a little better your own mind in connection with the Second Amendment. So for those of you who are advocates of the Second Amendment, and of course there are many, I hope I can help you understand a little bit more why you like the Second Amendment and think that it's important, and why private arms possession is worthy of a constitutional protection. And for those of you who are critics of the Second Amendment, maybe you'll be able to understand a little better what you think are wrong with the arguments for the Second Amendment by understanding a little better what those arguments are. So our question is, why have a Second Amendment? Why constitutionally protect private arms possession? And I should emphasize that I'm not interested in the historical question, because I'm really not an authority at all on the historical question of why the founders created the Second Amendment. My goal is to understand contemporary arguments for the Second Amendment, why people now think the Second Amendment is an important thing. And I'm just interested in that topic, not necessarily because it's a legally important question, but because I think it's important for us just in understanding one another to figure out why this is such a popular and, among other quarters, a very unpopular constitutional right. All right, so to start out with, let's just try to create a model about why anybody would have a constitutional right at all. Why constitutionally protect anything? That is, why not leave everything up to democratically elected institutions, right? Why not let the majority decide everything? Why carve off certain areas or interests that are outside of the democratic process, that can be struck down by courts on the grounds that they have violated certain fundamental interests? Why do that? I think it's not enough to say, well, you need constitutional rights because the government will make mistakes. It's really part of the idea of governmental authority, the very nature of the government, that it can make mistakes and that we're bound by its mistakes. We cannot challenge as inapplicable to us laws that have bad content, simply because the government has come up with a law that we think is wrong, misguided. The speed limit should be 55, it shouldn't be 65, and so on. That is not enough to claim that the law is illegitimate. We think that we have an obligation, at least those of us who are not anarchists, believe that we have an obligation to abide by laws, even if those laws are misguided or wrong. That's the privilege of the government, is to make errors. That's sort of the nature of authority. So we can't say we need a constitutional right to make sure that the government doesn't make mistakes. That can't be our argument. It must be that, there are certain areas that are just so important that we want to limit a democratic government, a majoritarian government's discretion. And I think that there's sort of two requirements for having a constitutional right under this theory. The first, is that there's got to be a fundamental interest at stake, something that's exceedingly important. And a fundamental interest might be something where if the government violates that interest or impinges upon that interest, it actually means the government's acting outside of its authority. That's possible. But we might also have a theory where fundamental interests can be violated by the government without it losing its authority. Nevertheless, it's a bad thing if the government does that. And so these are particularly important interests that we want to protect. And secondly, I think for a certain interest to be protected in the Constitution, in the Bill of Rights, for example, there's got to be a risk that it's going to be violated. If I were to come up with a list of fundamental interests that I think are very important, I would have a much longer list than what you see in the Bill of Rights. The ones that I think were chosen for constitutional protection is the ones that were vulnerable to being violated. That's why they thought that it was necessary to provide particular protection against democratic majoritarian institutions, against legislatures and elected officials, right? So here's just an example of this theory in action, the Fourth Amendment, which protects us against unreasonable searches and seizures. By the way, I'm going to be vague here and talk indiscriminately, except in a few cases, about the federal government and the states. Technically, the Fourth Amendment applies only to the federal government, and then incorporated into the 14th Amendment, it applies to the states. But I'm just going to speak vaguely about the Fourth Amendment as a protection against federal action and against state action. It just seems to be moving on its own, doesn't it? I wonder how we can stop that from happening. I thought it was me, but the Fourth Amendment, yes. We're going to do it this way. Right. Is this all right with you guys? Great. What fundamental interest does the Fourth Amendment protect? Well, it seems to protect privacy, right? And it's understandable that that would be a very important interest that would be worthy of constitutional protection. But what's the risk that that interest is going to be violated? It's an important fundamental interest, but why is there a risk of it being violated by the legislature or the executive? Why can't we trust elected officials to protect these interests? And I think the reason why is that the government is actually sensitive to the concerns of the majority and want, this is the main reason why it's vulnerable to violation, want to have efficient enforcement of the criminal law. So the idea is that on the one hand, we have the privacy interests of those suspected of crimes, and then we have the interest that the majority has and elected officials have in efficiently enforcing the criminal law and uncovering crimes. It's the fact that protecting this interest of privacy has negative consequences, meaning very potentially an increase in crime. The fact that it has that cost, that we need to protect the privacy interest through the Fourth Amendment, because elected officials are going to be inclined, not because they're bad people, but are going to be inclined, because of clamoring from the majority itself, are going to be inclined to override Fourth Amendment rights, override privacy interests in the interest of criminal law enforcement. How about the Eighth Amendment? The Eighth Amendment prohibits cruel and unusual punishment. All right, so what is the fundamental interest? standing behind the Eighth Amendment? It seems like something like individual dignity, right? The interest that someone convicted of a crime has not to be submitted to really gruesome punishments. Well, why is it likely that this interest would be violated by a majoritarian government? Well, if you want maximal criminal law enforcement, if you really want to discourage crimes, gruesome punishments are really a nice way of doing it, right? The more gruesome they are, the more likely people are going to be afraid of such punishments and disinclined to commit crimes, right? So once again, we have the majority and its elected officials, in the interest of criminal law enforcement, being inclined to violate this fundamental interest of people. We might all have this fundamental interest, but in particular, people convicted of crimes have it, right? So we have the fundamental interest and the risk of violation. Just one more example, the First Amendment. Congress can't abridge freedom of the speech. It applies more broadly than to Congress. What's the fundamental interest here? There are a lot of theories out there about what fundamental interest the First Amendment protects. One theory is that it protects individual autonomy. I have an interest in expressing my viewpoints about aesthetic, political, any sort of matter. And just skip for a second, what's the risk that that interest will be violated? Well, the majority, and the government that's responsive to the majority's interests, might say, you know, what that guy's saying is really dangerous. We need to shut him down, keep him from speaking, in the interest of public safety, right? So that's a theory about why we have a fundamental interest and why we have the risk of its violation. There are other theories about the First Amendment out there. The First Amendment might be primarily about expressing views so that the majority can come to a considered judgment about what should be done, right? What laws are best. In that sense, the First Amendment might actually foster the majority's interest, democracy's interest, rather than being a limitation on democracy out of the interest of individuals, right? So we've got this question about whether the First Amendment is really about helping the majority, right, helping democracy, or whether it's about limiting democracy in the interest of particular individuals who happen to be disfavored by the majority in its government. If the First Amendment's about political participation, speaking so that there's the views out there that will allow the majority to come to a considered view about what laws to have, well, then the risk of violation might be an entrenched minority in the government, perhaps trying to suppress dissent, right? That's a possibility for why the First Amendment is, those interests behind the First Amendment are at risk of violation. At any rate, I hope that this gives you sort of a feel for what constitutional rights are about, right? They're protecting certain fundamental interests, usually of individuals, not always, and these are interests that are at risk of violation because the majority and its elected officials find respect for those interests inconvenient or disadvantageous in some way. Not always out of bad motivation, sometimes out of very good ones. Well, what about the Second Amendment? The Second Amendment protects the right of the people to keep and bear arms. I'm going to talk, I know I wrote a paper offering 9 theories of the Second Amendment, and I stand by that, actually, but I'm only going to talk about 5 theories right now. But take my word for it. I do think that one thing you'll come away with is that there really are a lot of arguments for the Second Amendment. I'm not going to take a stand on the virtues of the arguments, but there are distinguishable arguments out there that have their own merits and their own disadvantages. The first is sometimes called the collective rights theory. This was the reigning theory of the Second Amendment up to the Supreme Court's decision in Heller. So this was the one that federal courts and state courts interpreting the Second Amendment used in figuring out what its scope was. I don't think the collective rights theory is a very good description of it. It's more the states' rights theory. I think that would be the better way of putting it. So what's the fundamental interest standing behind the Second Amendment under this theory? It's states' interests, not the people of those states and not individuals, states' interests in having a well-regulated militia, by which it was taken to mean a national guard, right? So this is quite an important and very different view of a constitutional right than the other ones that you get, First Amendment, Fourth Amendment, Eighth Amendment, rather than protecting, under this interpretation, rather than protecting a right of individuals, it was protecting a right of the states against the federal government, not a right of individuals against state or federal governments. So one thing that would follow from this theory is that really there can't be any Second Amendment violation by the states, because it's really their right. What then is the risk of violation? Well, the federal government might have a desire to protect itself against a rival, right? And it's also possible that the federal government might be worried about public safety problems with arms possession, and therefore these concerns might lead it to try to restrict arms possession in a way that would impinge the state's ability to mount a militia, really a national guard. But so that once again, to sort of give the general idea of this theory of the Second Amendment, states' militias stand as a bulwark against encroachment upon state power by federal government. That's sort of the theory standing behind the Second Amendment. One thing that's true about this theory, which has now been rejected by the Supreme Court, is that there's practically no chance that any restriction of firearms possession would violate the Second Amendment under this reading. It would have to make it difficult for the National Guard to perform its function. It would have to impinge upon states' interests rather than the interests of individuals. All right, so let's move on to the second theory of the Second Amendment. I'm not going to spend any more time on the first theory. It's, in a sense, water under the bridge. The insurrectionist theory is a different one. What's the fundamental interest standing behind the Second Amendment? Now it's the interest of the people, right, as a whole. One might even say a majority. It's protecting the majority and their interest in having democratic self-governance. So the idea is that they can use arms to rise up against a tyrannical government, a government that's not respecting the majority's interests. What's the risk of violation? Why would we need to protect this interest? Well, there might be a tyrannical government arising, and maybe one of the first things that it would do is start disarming the population so that they can't rise up against it. But it also might be the government and even the majority's own desire to protect themselves against violence. So under this second approach, it's possible that the Second Amendment is sort of binding the majority's hands in its own interest. The idea is that the majority might become so worried, through its elected officials, so worried about violence due to arms possession that it misguidedly disarms the population, thereby allowing a tyranny to arise. So when it's put this way, the Second Amendment is a way that the majority itself can restrain its own ability to act in its own interest. That's a theory behind it. But another possibility is that maybe an entrenched minority in the government gains power, is acting really against the majority's interest, and engages in disarmament in order to keep a violent revolution from happening, or at least from succeeding. So once again, now the general idea here is that the people as a whole, we're not talking just about states here at all, the people use their arms to rise up against a tyrannical federal or state government. So under this theory, the Second Amendment would be binding upon the states as well, just as much as it might bind the federal government. I just want to talk about two challenges, problems with the insurrectionist theory. I'm not going to spend time talking about whether these challenges work or not, but it's a concern about this theory. It is, one might say, questionable whether an armed population can effectively challenge a tyrannical government, particularly if it has the armed forces behind it. So someone might say, well, the Second Amendment under this theory simply isn't going to work because an armed population just doesn't have the capacity to rise up against the military, assuming that the military is standing behind this tyrannical government. But someone might say in response, well, it's a deterrent, and it may be a sufficient deterrent to keep a tyrannical government from arising. Even if the tyranny would be able to eventually overcome an armed population, it would be so costly that it would discourage a tyranny from arising. A second challenge for the insurrectionist theory is this idea that if the Second Amendment is in the interest of the majority, so that the majority will not ill-advisedly disarm itself and thereby submit itself to the possibility of tyranny, it is a little odd to say that the majority can't make its own judgments about this. If it really is about protecting the majority's interest, protecting the people's interest as a whole, shouldn't we allow them to decide whether they would prefer a risk of tyranny over what they perceive to be excessive armed violence, individual on individual violence by force of arms. Shouldn't that be the kind of judgment that they should make? Once again, I'm not going to say whether these arguments work or not. It's just a matter of description. The third theory of the Second Amendment I call the tyranny of the majority theory. So the idea is the previous theory was one where the Second Amendment allowed the majority, the people, to rise up against a tyrannical government, right? That's what the purpose of it was. It was protecting the majority's interest, the people's interest as a whole. Here, the Second Amendment is protecting individuals against the majority. What's the fundamental interest here? Well, really, it's all the interests that individuals have, and this arms possession allows them to protect those interests if constitutional protections fail. So the idea is we have constitutional protections for First Amendment rights, Fourth Amendment rights, and so on. But those might fail. The majority might override the fundamental interests of individuals. And the Second Amendment allows a backup protection. And that backup protection is the individual can use force of arms to protect his individual interests against a majority government, a democratic government, that is overriding his fundamental interests, overriding his rights. The risk of violation here is that the government or the majority will find the interests of individuals, the fundamental interests of individuals, inconvenient sometimes or distasteful, right? And therefore will be interested in pursuing its own interests to the disadvantage of the individuals. And the really sort of classic image of this is African Americans after the Civil War using their arms to protect their rights. We're talking about a minority protecting their rights against the white majority, right? So this is a very different image of what the Second Amendment is doing. Once again, not protecting the majority's interest against a tyrant, but rather protecting individuals or minorities against a tyrannical majority. By the way, it's possible, I think it's worth saying this, it's possible for the Second Amendment to have a number of different justifications. This is not an either-or matter, but these are different arguments. A challenge for this argument, I think, is that widespread arms possession under the Second Amendment would also create an armed tyrannical majority, right? The majority that's oppressing the minority will itself be armed. And so it's an empirical question about whether it's really in the benefit of a minority that might be oppressed by the majority to have widespread arms possession. That allows them arms to protect their interests, but they may, in fact, find that they're at a worse disadvantage with widespread arms possession than they would be otherwise. All right, you'll notice that so far I have said nothing about use of arms to protect yourself against a violent intruder, right? It's all about the relationship. So far, it's been all about the relationship between individuals or the states and the government, right? The government is the one that is going to be violating your Second Amendment rights. The government is the one that's going to be impinging your interests in connection with the Second Amendment. But what about someone coming into your home, right? Let's imagine that an intruder comes into your home, and this is actually from the Heller case. The government, in the interest of public safety, what it perceives to be a matter of public safety, has imposed a trigger lock requirement. Requires that there be a lock that has to be opened with a key before the gun can be used. And as a result of that law, you're not able to defend yourself efficiently. Does that violate the Second Amendment? Now notice that there doesn't seem to be any problem with this law from the perspective of the earlier three justifications. For example, let's give you one example. If the Second Amendment is about the ability to rise up, for the majority to rise up against a tyrant, the trigger lock mechanism is really not going to be a problem. If a tyrant arises, you just unlock your gun and go, call to arms, man the barricades. And I really don't think, it's certainly not a problem for the first justification, not even really a problem for the third justification, the tyrannical majority justification. This is capturing a different type of interest, the interest that you have in protecting yourself against violence by third parties, not governmental violence, violence by third parties. And nothing we've said so far in connection with justifications for the Second Amendment, it really speaks to this question. So does the Second Amendment have anything to say about that? Is there a justification for the Second Amendment on the basis of those types of interests? So the first theory I'm going to talk about is the safety theory. What's the fundamental interest you have? It's an individual interest. Now, it's not an interest of the state. It's not an interest of the majority. It's an interest of an individual in safety from harm or death, having a certain level of safety and protection from violence by third parties. So the idea is that private arms possession makes us safer from violence than we would be otherwise. And that's such a fundamental interest that we need to constitutionally protect it. The first challenge to the safety theory is this empirical question, and I'm not going to say anything about it. There's a lot of literature on it, about whether a system of private arms possession really does make us safer or not. It is true that if I own arms, by virtue of that, I'm probably made safer compared to a fixed population. So let's assume everybody else is disarmed. If I own arms, I'm safer as a result. I'm armed and they're not armed. Likewise, if everybody is armed, and then I arm myself, that act also makes me safer. So whatever anybody else is like, I'm always individually made safer by virtue of arming myself. That seems true. But it may be the case, and as I said, this is an empirical and a difficult empirical question. It may be the case that if everybody owns arms, I'm actually less safe than I would be if everybody were disarmed. Now, those aren't the only options. Unrestricted arms possession and complete disarmament are not the only options. There are many others. So this is a very difficult question, but it is an empirical question that would potentially undermine the safety argument for the Second Amendment. So the idea is it's possible that mutually imposed risks of arms possession. When I own arms, I impose a risk upon others of mistaken uses, that might actually, when we put everyone together with arms, might make us all worse off. Might make us all worse off than we would be if we were all disarmed. The second challenge for the safety theory is let's assume this trigger lock requirement is misguided. It actually makes us less safe. It does seem that one of the sort of fundamental purposes and powers of the government is to make judgments about the proper way of bringing about public safety, even if they're wrong, even if they're mistaken. So the government might misguidedly prohibit a drug that I need for my disease that I have. The government's wrong. It's actually a perfectly appropriate drug, and I need it for my disease. I'm bound by that decision, by the government's decision. So that's something about that strongly impedes my interests, right? It's disadvantageous for me. But we don't think that on its own, even though the result of the government's decision might be my death, we don't think that's enough on its own to allow me to escape from the government's laws. Or governments make decisions about where police enforcement should be placed, right? That has profound effects on our safety. And nevertheless, we think that it's within the government's power to do that. Or the government might make a decision to send people to war, leading to their death, right? Thinking that judgment is appropriate, maybe it's misguided. Nevertheless, we're bound by that judgment. There's so many areas where the government makes life or death decisions that we nevertheless think are within its authority. So why would arms possession, this question about whether arms possession is allowed or not, why would that be something, a matter of public safety that stands outside the scope of the government's authority? Just throw that out. The third challenge to the safety theory, and I'll be very quick here, is that the risk of violation. I haven't yet described why the government might be motivated to override or impinge upon the individual's interest in safety. Generally, when you see the justifications that are given for restrictions on arms possession, it's public safety interests. So this is a very odd thing about the safety argument for the Second Amendment, is that under the theory, the interest that's protected is individuals' interest in safety. But the reason why the majority is trying to override it is interests in safety. This sort of suggests that we're actually in a realm of legitimate public debate, not constitutionally restricted, about how to make the world a safe place. And I'll just throw out one more challenge for the safety theory, and I think this is actually the most important. I'm very sympathetic to people who find that the Second Amendment resonates with them. And when I speak to them, I find that often they don't really care whether the Second Amendment makes them safer or not. That's actually not what's important to them. Even if, as a matter of fact, they're made less safe by a system of private arms possession, they still think the Second Amendment is justified. Now, in saying that, they sound very much like advocates of the Fourth Amendment or the Eighth Amendment or the First Amendment. Because remember, the Fourth Amendment makes us less safe. We are more vulnerable to crime as a result of the protection for privacy that the Fourth Amendment gives us. But we don't think that that's a problem. We think it's important to protect privacy interests precisely because they're vulnerable to being impinged upon because they make us less safe. Likewise for the Eighth Amendment or the First Amendment. The idea is that we want to protect these interests, with these important interests that we have, despite the fact that we're made less safe as a result. And it's precisely because we're made less safe as a result that they need constitutional protection. It's precisely for that reason that, that the majority that's sensitive to the interests of the public might override those interests. Okay, so that suggests that there's really something other than safety going on, standing behind the intuitions of people who think the Second Amendment's justified. Now, one explanation is the insurrectionist theory. Somebody might say it's important, despite the fact that we're less safe in a world where people have a lot of arms, it's important that we have that as a backdrop to keep tyrants from arising, right? That would make sense, right? You could say, yes, we're in a less safe world, we're more vulnerable to gun violence with the Second Amendment in place, but guess what? We won't have a tyranny arising. So that is a way of explaining people's intuitions that the Second Amendment is justified, even though it makes us less safe. But I think there might be another possibility, which is an autonomy theory of the Second Amendment. And this is something that I've myself written on. So what's the fundamental interest? By the way, how much time do I have? Do you know? 25. Oh, we'll have plenty of time for questions then. So the fundamental interest might be an individual's interest in controlling his response to threats and to wrongdoing. When I'm armed, I am, in a sense, more autonomous. I have a greater capacity to vindicate my views about rights violations and enforce them. And it might be that that autonomy interest is worthy of protecting, even if the collective result of everyone having this autonomy interest respected is that we're all made less safe. So this may be a different type of interest, an interest that is closer to the interest that you get in the First or Fourth or Eighth Amendment. This makes the Second Amendment look more like the other provisions in the United States Constitution, in the Bill of Rights, because it's protecting an autonomy interest that we think is worthy of protection, despite the fact that it makes people less safe as a result. What's the risk of violation? Well, then it's the same motivation that the government will have to impinge upon this interest that you get in connection with the First, Fourth, and Eighth Amendment. The attempt to solve the problem of crime and violence, right? The government's inclined to violate privacy interests because it wants to discover who committed the crimes. It's a noble motivation, but the worry is that they will override people's privacy interests. Well, here, under this theory of the Second Amendment, the government is concerned about gun violence and will override the autonomy interests that people have in arms possession. This is this theory, at any rate. So the general idea is that private arms possession gives individuals the power, through possession of an instrument, the power to decide how to respond to violence, particularly violence that's perpetrated against them by third parties. So now for a challenge for the autonomy theory. One way of thinking about this interest that stands behind the Second Amendment under the autonomy theory is it's the interest that we all had outside of governmental authority. I say we all had. We have never been outside of governmental authority, but we can imagine what it would be like if there were no government, if we were in the state of nature. One of the things that's really attractive about the state of nature is that we have the power to determine who's violated our rights and vindicate our views against them. So if I think that you perhaps have violated my rights, I can do something about it. I can punish you myself. I'm able to exercise my autonomy and express my views about what rights have been violated or not. And I can do the same thing for my kin, right? That is a powerfully attractive idea, that I would have the ability to use my own agency to express my own moral views. It's certainly tied to the idea of autonomy. There is a problem, however, about the state of nature. It's a classic problem described by John Locke, which is that people who, if you're in a world where people are able to vindicate their own views about rights violation, you get feuding, you get people misjudging their own case, viewing their own rights as greater than they actually are. Everybody is doing that, and the result is that we're made less safe in such a world. The attempt to this, in one way, very attractive world where people are able to exercise their own judgment and use their own agency in determining whether rights have been violated. The problem with that world is that everybody misjudges their own case and the case of their kin, and we get feuding and an increase in violence than we would have if we gave over that power, the power to vindicate our rights violations, to the government. And that's the theory, at least a theory that a lot of people have, about why we submitted to the government in the first place. We submitted to the government because the costs of this autonomy were simply too great. So then that would suggest that the interest that's being protected by the Second Amendment, which I think is a really powerful interest, this autonomy interest, is something that's incompatible with governmental authority. It's the reason why we're attracted to arms possession is we thereby have that power that we had in the state of nature. But the point of governmental authority is that we're supposed to be leaving the state of nature. I think that's the reason why so many people who are not sympathetic to the Second Amendment think that it's in some sense anarchistic. It's in some way incompatible with governmental authority. That people who are attracted to the Second Amendment just don't like government at all and want to go back to the state of nature. This is captured a bit by the autonomy argument. However, I don't think the autonomy argument is, I think the autonomy argument can actually be salvaged from this criticism. We would have to understand it as being a limited autonomy right. Second Amendment rights don't give me the right to be Rambo, right? I don't have the right to do anything I want with my arms, right? It's going to be a limited autonomy right. It gives me a certain power that I would not have otherwise to vindicate my own views. When someone comes into my house, I may use my gun to protect myself. Even though a world where I was disarmed and my attacker was disarmed might be a safer world for me, that world where I'm able to use my arms is a world where I have a greater autonomy. That's a good world, but it's a limited autonomy interest. This may seem very odd to you, but I think there is an analogy out there. I think there are actually a number of areas where there have been protections created for particular rights that are the very type of rights we have in the state of nature, the very type of autonomy rights we have in the state of nature, but they're very restricted. So the idea is we give people certain areas where they have that autonomy they had in the state of nature because it's really important to them. Although within a broader framework, of course, we have a lot of governmental authority. And that is the right to bring a lawsuit. You may think, what's the relationship between the Second Amendment and the right to bring a lawsuit? In fact, I think that there's a very close relationship there. I've seen relationships between the Second Amendment and lots of things, so you might say I'm a little too creative in this area. I see relationships between the Second Amendment and the privilege against self-incrimination, too. But I do think there's a relationship between the Second Amendment and a right to bring a lawsuit. In the state of nature, if I think somebody's done something wrong, I can confront him and punish him. We can't allow that anymore. We need governmental authority. We have to have vindication of rights through courts, right, and punishments brought by the government, right? Because if we allow it to do it ourselves, we're going to have feuding and all the disadvantages of the state of nature that John Locke speaks about. However, it is very interesting that we've reserved this right to bring a lawsuit. Think about this, right? We don't have to have it. I'm talking about a civil lawsuit. If somebody runs over me with their car, let's say I'm still alive, so they run over my foot with their car. We could have a system where I would go to the government and say, please vindicate my rights. And there would be something beneficial about that, because if we had to go to the government to make sure that our rights were violated, you wouldn't have so many frivolous lawsuits, right? People misjudge their cases, are always suing about things that they think have been done wrong to them. And because everybody thinks that their rights are broader than other people's rights, you get a lot of lawsuits being brought against one another. We're in a worse world as a result of the capacity to bring a lawsuit. So in one sense, it would seem to be really a good world if we gave over to the government this power to vindicate our rights. But I think that people would find that their autonomy had been reduced in a very serious way if they lost the right to bring a lawsuit. The fact that I have this power to be able to say to somebody, you violated my rights. And of course, I may be misjudging it, right? Maybe the person didn't violate. Maybe it was someone else who ran over my foot. But the fact that I've got this capacity, despite all its costs, have this capacity to confront somebody, this capacity that I had within the state of nature, is a very important part of my autonomy. Despite, and I've got to emphasize that, despite the fact that it has some of those disadvantages of the state of nature. Everybody misjudges their case. People are going to be suing one another. We're in one sense a worse world as a result of that. But autonomy is important to protect nevertheless. Well, I think the Second Amendment has, under this theory, has something analogous to it. By virtue of arms possession, and we're not talking about unrestricted arms possession, but by virtue of arms possession, we've vindicated a particular autonomy interest. We've recreated in a small way, in a limited way, that ability of self-enforcement that you have within the state of nature, despite the fact that everybody else having that autonomy interest protected might make us worse off because people make mistaken views about when their arms can be appropriately used or not, right? It may be that this is really a justification for the Second Amendment that's very much along the lines of justifications for the First, Fourth, and Eighth Amendment, in the sense that there's some kind of important fundamental interest of individuals that we want to protect, despite the fact that we are made less safe as a result. And I think I'll end it with that and just take questions. Yes?
Not pro or con gun control, but the bad guys don't live up to any of this.
Right.
And I think that's the biggest argument the advocates for self-protection follow. I don't know how to answer it, but they don't follow the same rules.
So that gets to the safety argument, right? That's really where that would be relevant. The idea is that, remember I mentioned one important question in the safety argument is whether widespread arms possession or disarmament is the system that would make us safer. And of course, it's a natural criticism that disarmament wouldn't make us safer, is that the people who are most difficult to disarm are the criminals, right? So I hope to capture that by the idea that it really isn't true that the only two possibilities are complete disarmament, because that may be impossible, or unrestricted arms possession, because that's not, you don't necessarily have to have that. But notice the other arguments besides the safety argument. With respect to those arguments, it really doesn't matter if arms possession makes us less safe. Right? The idea is that even though the Second Amendment makes us less safe, let's assume that that's true, there's still something worthy of protecting. So this important argument that people have about whether arms possession or disarmament is going to make us safer, that's really irrelevant to most of the arguments that we've been discussing. Right? Same thing is true, I'll just give you an analogy of the Fourth Amendment. People might debate about whether the Fourth Amendment makes us safer or less safe. I think it's pretty clearly makes us less safe, but there may be a disagreement about that, right? But it really doesn't matter to the justification of the Fourth Amendment whether it makes us less safe. In fact, people who think the Fourth Amendment's important think it's important despite the fact that it makes us less safe, or actually because it makes us less safe. We need this constitutional protection for privacy because protection of privacy makes it more difficult to enforce the criminal law, and we're made less safe as a result. That's precisely why we have it, right? So I think it's important to realize that in connection with all but the safety argument for the Second Amendment, whether gun control works or not is really irrelevant. What's relevant is this other interest, and I remember I spelled out a number of them, this other interest that's worthy of protection despite the costs, where the costs would include the fact that, that we're made less safe, or maybe not, right? Yes?
Was it not Yamamoto that said, and it could be another leader, that said the reason they didn't attack the mainland was not fear of our government, but fear of the armed citizens
Right.
and the retaliation?
So first we had really the safety argument in action, if you don't mind my attributing that to you, but I think that's really what you were talking about. You're bringing up the insurrectionist argument, right? So you're saying, well, the purpose of the Second Amendment, I mean, you'll see this happens to me all the time. I'll hear lots of argument coming out, and I can pick out which one it is. There's a diversity of views, even among advocates of the Second Amendment, diversity of views about why the Second Amendment is a good thing. You're saying the Second Amendment performs a crucial purpose in discouraging tyrannical government, and I didn't mention invasion, but of course that's another form of tyrannical government. And that may be it. That may be the full story behind the Second Amendment, is that it's protecting that interest despite the costs, whether or not we're made less safe as a result right now in terms of interpersonal violence. We have that bulwark against invasion and tyranny. That may be all we need to justify the Second Amendment. It is interesting, however, that that justification probably wouldn't work to prohibit the trigger lock law, right? Which was one of the laws that was struck down in Heller. So it does seem that this insurrectionist theory of the Second Amendment is going to create a more limited Second Amendment than a lot of people would like. And so you should just consider that. If that's the one that really resonates with you, and I know a lot of people where it does, if that's what resonates with you,
I don't want the government to come in
right.
when they're not any longer protecting us.
Right. Right. Actually, and I might say I'm hearing maybe hints of the third justification as well, where you're thinking, well, maybe even a majoritarian government. The people might be bad, right? The people can override my individual interests, and I would then have the power to use arms to protect myself against them. That might discourage them from violating my rights, my individual rights. Yes?
You got into the militia, and that, a lot of people interpret that the Second Amendment is to protect the British from coming in and taking over our homes and us to be able to fight the governments, or she mentioned other governments. Wouldn't that restrict, if that is the argument of what it is, you have the restrictions of felons not owning guns. You said the military would be able to overtake us anyway because they got the big guns.
Right.
So would it go to where people can have their own rocket launchers?
I mean, you're asking marvelous questions.
And then as far as the protection in your home or somebody mugging you, I would, like you said, some of these things cross over into other protections. The right of privacy, of me to privately have that gun for that protection, would be more of the argument for that than the Second Amendment, which seems a lot of arguments are a militia to protect against states and federal governments or other governments from other countries.
Well, so I don't know if anybody, is this being taken up by the tape? Probably not. Maybe I should repeat it. It's not? I'll have to repeat them. Okay. Well, you were asking really what I think is you're asking a number of things, but one really important question about the scope of the Second Amendment. It will vary given its purposes, right? It's natural to interpret the scope of a constitutional right in terms of what the constitutional right's trying to do. We certainly do that for the Fourth Amendment. If you didn't really know what the Fourth Amendment was for, you wouldn't know where it prohibited governmental action and where it didn't, right? So you have to look to it in terms of its underlying purposes. If you're quite right, if the Second Amendment is about aiding an insurrection, right? It may be that the type of arms that are covered by the Second Amendment are more broad than they would be under other theories, right? For example, under the autonomy theory, where the Second Amendment is more about a limited vindication of an autonomy interest, it may be that just a certain type of arm will satisfy that interest because it's actually not performing an important functional role. It's more of an expressive role that I have this and able to use it to vindicate my sort of response to violence in my home. If that's a justification of maybe a smaller number of arms, on the other hand, if we're saying that the Second Amendment is really there to allow for effective deterrence of tyranny, it maybe have many more arms that are subject to Second Amendment protection. The laws may be more limited. The trigger lock law, for example, might not be unconstitutional because it's not incompatible with insurrection, but the number of arms might be broader, right? So that's one thing that's important about figuring out what your theory of the Second Amendment is because it has really important consequences for your determination, and I'm talking about courts' determination as well, about what the scope of the right is. I'm sorry, you brought up something else that I forgot. Can you repeat anything that you thought I didn't answer?
On the militia side or the privacy side?
Yeah, well, the militia bit, I did. Now, there's, of course, a tradition of reading the militia very narrowly. I haven't said anything really about textual interpretations of the Second Amendment as well. You'll notice that. I'm really coming from my background in philosophy and political philosophy, where I'm talking about it in a much more abstract way, but I think an important way. I haven't talked about that, the prefatory clause about a militia that had been read very narrowly to refer to something like the National Guard, and in which case the Second Amendment was really eviscerated, right? It was just a protection. That was the first theory, protection to states, so that they would have something like the National Guard. The interpretation seems to be broader now, where the militia is understood as more coextensive with the people, and given broader understanding of who the people are now, not just white males or white property males, it's everybody, right? It really just includes the people as a whole. So the language of the militia is performing less of a restrictive, or really no restrictive function on the Second Amendment anymore, at least under this theory. Yeah.
Could you briefly, people don't realize how much George Mason had to do with this
Yes.
and having these Bill of Rights. Could you say something about him?
I'm just going to confess. I went to George. I was a professor at George Mason Law School, and I'm, roughly familiar with George Mason's responsibility for the Bill of Rights by virtue of Virginia's. But I don't know enough about it.
Constitution because it wasn't in the
Right? You wouldn't want to hear me talk about it because I don't know sufficient about it to give you anything that's worthwhile. I'll confess my ignorance. There are a lot of people who are very, very good on the history. I do know a little bit that there's not a lot of legislative history. That is, there isn't a lot of discussion about why the Second Amendment was included. So that's why we are, in a sense, thrown back on our own devices. By the way, this is true for most constitutional amendments. We don't really know why they were put in, and so what's important to us is just figure out a good moral theory. The founders were rational people and moral people. If we come up with a good moral theory, that probably was theirs as well, right? So that's pretty much what we're going to have to do. So that's why I think what I'm talking about might have some use for people who, in the end, are going to try to come to the difficult judgment of what, as a legal matter, the Second Amendment means. Yes?
You finally brought up a word I was looking for, and that's, first of all, I admire the fluidity of this. If I'm challenging, making a court challenge about using one theory, I can sidestep that one and move into another if I need to. So the fluidity of this is great. But I'm really interested in how morality or an ethic of the country, whether it's the government or the majority or the minority, how does that ethic, I hear greater good and some utilitarian theory. So the ethics of this is really amazing. So with your philosophy background, tell me a little bit about the ethics, the ethic.
So by ethic, you're really referring to sort of more about views about morality that particular people have.
Yeah. Well, I'm not trying to
talk about what is moral or not from a God's eye perspective. I think it is a profoundly important point that Americans are much more attracted to a protection for private arms possession than people in other countries. It's actually a little broader than that. You find it everywhere in the Western Hemisphere, not just in the United States. You find it in Brazil and Argentina as well. And so I've done a lot of, go to international conferences, and occasionally I'll talk about the Second Amendment. And the Latin Americans are always, sound very much like the Americans in that respect. And yet Europeans have a very, very different view about this. I think that is very important in trying to understand the purposes of the Second Amendment. It's likely to be protecting something that Americans find more important than Europeans do. And so the question is, what is that? If it were protecting safety, right, if that were what the Second Amendment was about, protecting a certain level of safety, you wouldn't think that Europeans and Americans would have different views about that. Nobody likes to be unsafe, right? So that suggests to me that there's something else standing behind the Second Amendment. Likewise, frankly, Europeans have a really terrible history with tyrannical governments arising. And if the Second Amendment then were about, I mean, the Swiss may be a little bit different this way, but about arms possession as a bulwark against tyranny, once again, you'd kind of expect the Europeans to understand and appreciate that. And yet you don't really. And so that's what leads me to believe that what's actually motivating the differing views about constitutionally protecting arms possession in the United States and in Europe is the autonomy argument. I think it's really Americans have a greater, and this has to do with historical tradition about the frontier, have a greater desire to enforce rights themselves, a greater interest in self-help, in vindicating their rights. It expresses itself in the American tort system, too. It expresses itself in how many lawsuits there are in this country. There's a certain feeling that I'm not going to let the government make the decision for me. I'm going to do it myself. That's something that just simply speaks to Americans, much more than it does to Europeans. And so it would make sense then that you would have greater protection for arms possession in the United States, greater protection for private lawsuits in the United States, and so on, right? And quite frankly, movies that express this attitude all the time. And we find that deeply attractive. When somebody finds that the government has done a bad job, what happens in a movie? This is like 50% of all movies that you see. The government's done something wrong. It's not vindicating rights properly, and the individual comes in, usually by force of arms, and takes care of it himself. And we cheer such a person. Why? Because we know that we can't do that. We'd actually be thrown in jail if we did. But we see an expression of a certain type of autonomy that we just find deeply attractive.
So I know I agree with that as well. There is an American ethic that I'm not judging goodness or badness,
Right.
but there's an American ethic, I think, that's very much to play with all of these.
Right. And it's independent of the fact that there, in fact, was just widespread arms possession in the United States to begin with. It's independent of that. It's a more fundamental moral view that Americans have.
One more question.
Sure. Oh, I'm sorry.
Oh, go ahead.
You could battle it out. Arm wrestle.
Go ahead.
Well, what I do know is someone should speak, because
My question is, I appreciate the, like Carrie said, the fluidity of all the arguments and everything, but I'm wondering how evolving technologies play into any of that. Arms are evolving all the time, weapons are evolving all the time. The capacity to do enormous harm is evolving all the time, and where does that enter into the equation?
well, so your question, so this is a question about the relationship between technology and technological advances and constitutional rights. I think it's a much broader question than the Second Amendment. It is crucial with respect to the Second Amendment, but it's a problem with respect to the First Amendment or the Fourth Amendment. Think about the Fourth Amendment, right? These capacities for invasions of privacy are so much greater now than they used to be that we simply cannot interpret the Fourth Amendment by looking to what the founders would have said. They really don't have the technological or intellectual basis to make a judgment about this. They simply didn't have anything like that back then. So in that sense, the Constitution's got to be evolving. It's got to at least be interpreted in the light of changing facts about our society. And that's true about the Second Amendment, but I've got to say, how I would go about that will depend upon what justification you're using, right? As we saw, the insurrectionist theory does give an argument for this constitutionally protected arms to expand with expanding technology, right? Because the tyrant's going to have that technology, right? On the other hand, it's not clear to me that the autonomy argument would have that much of a change given certain technological advances. But I'll have to just leave it at that. That's it.